Hello, I'm Amanda Moore. I'm the director of the Clearinghouse Community. Welcome to the Advocacy Exchange for April 2017. The Advocacy Exchange is our monthly conversation with advocates advancing change. Both the Advocacy Exchange and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. So I'm happy today to welcome three guests with me. I'll introduce them to you in turn. We'll start with Saima Akhtar. Saima is a senior staff attorney at the Empire Justice Center, and she joins us today from Albany, New York. Hello, Saima.
Hi there.
And two of my colleagues are with us, two colleagues from the Shriver Center. They're both joining us from Chicago. I'll start with MacKenzie. MacKenzie Speer is an advocacy program associate on the economic justice team at the Shriver Center. Hello, MacKenzie.
Hey, Amanda. Thanks for having me.
And last but not least, we have Andrew Hammond. Andrew is a Skadden Fellow at the Shriver Center and is joining us from Chicago. Hi, Andrew.
Hey, Amanda. Thanks for hosting.
So Andrew and MacKenzie wrote our Clearinghouse article for this month. It is called SNAP's Time Limit, Emerging Issues in Litigation and Implementation, and that's what we'll be talking about today. And we've asked Saima to join us today because Saima's actually been litigating this in New York, so she can give us war stories and real sort of boots on the ground experience here today. Before we get started with our conversation though, I'd like to tell you a few housekeeping matters. If you would like to see the article that MacKenzie and Andrew wrote, and I encourage you to do so, it goes into more detail than we'll be able to get into today. You can find that on the Clearinghouse Community. That is at povertylaw.org/clearinghouse. So be sure to check that out afterwards if you haven't read it already. Now, we want to hear from you today during this conversation. If you have questions, if you've been working on this and have a tale to tell, we would love to hear it. There are a couple of ways that you can participate in our conversation today. One, some of you have already been using, and I'm happy to see you. That's the live chat as you watch through YouTube Live. So if you're on a laptop or desktop, that's to the right of your screen. If you're watching on mobile, I think you can kind of scroll up from the bottom and get the live chat. So I see some of you have already been testing it out and telling us where you're watching, and we're happy to have you. So thanks. And if you haven't tested it out yet, feel free to do that. If you don't want to use live chat, no judgment. You can send an email to me and I'll be watching that as well. My email address is Amanda Moore, M-O-O-R-E, at povertylaw.org. And so I'll be watching my email as well. So let us hear from you. We would love to take your questions while we're talking. So everyone who registered for today's conversation will receive a follow-up email probably later this week or early next week, and it will contain a link to MacKenzie and Andrew's article, a link to today's recording, as well as a link to register for next month's Advocacy Exchange, which we'll talk about at the end of the broadcast. So keep your eye on your inbox for that. All right, now let's turn to the matter at hand. We're talking about SNAP's time limit. And I want to make sure that we're all kind of on the same page as we start. So Andrew, I'll start with you. Can you tell us what this time limit is that we're talking about?
Sure thing. So this is a little known provision that was a federal statutory provision that was passed as part of the Welfare Reform Act of 1996. For the lawyers in the Hangout, I'll give you the site. It's 7 USC section 2015 O subsection 2. And basically what this is it applies to SNAP recipients who are between the ages of 18 and 49, unemployed adults who do not have a disability and they're not raising a child. So for this population, they cannot receive SNAP, which is formerly known as food stamps, for more than 3 months in any 3-year period or in any 36-month period. Now, the Obama administration actually waived this time limit as part of the stimulus bill, the American Recovery and Reinvestment Act. And so, for a few years, no state was implementing this time limit. That's changed and this has become kind of a cutting edge issue in SNAP policy and law generally across the country. So more than 40 states implemented the time limit in at least part of the state in 2016. So 26 states right now, as far as we can tell, have partial waivers, so waived the time limit in parts of the state. 17 states have implemented the time limit statewide. And then 7 states in DC, including the state of Illinois, have statewide waivers. So the time limit's not in effect in those states.
All right, and MacKenzie, I want to turn to you now. Can you tell us more about the population that is affected by this time limit, which, as people know from the title of this, kind of has the unfortunate acronym of ABAWD, able-bodied adults without dependents. Tell us more about that.
Yeah, so context, Illinois still has a full statewide waiver for our time limit, but one of the reasons we're putting a lot of time and energy into this topic is because the group that's impacted by this is an incredibly vulnerable and particularly poor group of people. That's who it falls hardest on. So as Andrew said, children and the elderly, folks with disabilities, they are exempt from this time limit. So that's almost 2/3 of the SNAP caseload falls into one of those categories. So the remaining group you have left are adults who are able-bodied, and like you said, Amanda, it's the horrible acronym ABAWDs, but what we really find in this group is, so you take out the folks who have children in their household, they also meet an exemption criteria, and you have this group left who, according to policy, should be expected to work, and actually about half we find while on SNAP are already working, so that group needs an exemption as well. But then you have this group who isn't either working at all or they don't have enough hours. And often this is because this group has low levels of education, they have low training, low skills. Ohio has been doing some really great work with full screening and assessments through a partnership between the food bank and the county offices there. And they've found a lot of undiagnosed learning disabilities amongst this group. Most people, I think like 1 in 3 don't have a high school diploma or GED equivalent. So it's really hard to find work and enough work when you have that level of barriers to finding 20 hours a week, which is what this time limit expects you to work. And so what we see when the time limit comes back is often a sharp decline in the number of SNAP recipients in this category because they don't simply go out and find work. They're still facing barriers and can't just go find a 20-hour-a-week job. It's quite difficult.
All right, I want to say hello to Luke, who's watching from Des Moines, Iowa. Thanks for joining us, Luke, and for letting us hear from you. I'll remind everyone, if you have questions as we get into the conversation, please let us hear from you. You can submit them through the live chat on YouTube, or you can email me at amandamoore, M-O-O-R-E, @povertylaw.org. Saima, I want to touch on something that Andrew mentioned, sort of in the flow of what he was talking about, that some places have reintroduced the time limit and some haven't. Can you tell us a little bit more about how that works and on what level of decision making that happens?
Sure. As Andrew indicated, the statutory provisions that authorize the ABAWD rule in federal law also create a carve-out, almost a, I hate to use the word fail-safe, but sort of a little bit of a release valve for situations where people can't realistically find jobs, we would say. And so the federal statute says that the secretary, meaning the Secretary of USDA and the people who run FNS, can grant a waiver for the ABAWD rule, this work requirement, in circumstances where there is an unemployment rate over 10% within a geographic area, or in an area where there is less provisions articulated in the supporting regulations and not in the federal statutory language. So essentially what happens is that if there are these findings made that either the unemployment rate is over 10% or you are in a designated labor surplus area, meaning that there are more workers than there are jobs under some very specific criteria, the ABAWD rules don't go into effect, which is a kinder and gentler, and I would say, because enforcing a onerous work rule on people who can't find jobs and for whom there aren't enough jobs isn't a realistic or a fair way of handling the program. The states are allowed to apply for these waivers, and when the waivers are granted, it's done not by the state, I shouldn't say not by the state as a whole. So in most states, the waiver isn't viewed as a single package. There's very complicated mapping and geographic data from Department of Labor that goes into the calculation and the determination about which areas get a waiver and which do not. And so as Andrew was also describing, there are a few states that are still under a full statewide waiver. Illinois and California would be the very large and obvious ones on the list that I'm aware of. The majority of states and territories are under partial waivers. New York with, and in New York we have more than half of our counties have re-implemented an ABAWD rule in some way, shape, or form. But actually in New York, it's not even a county level implementation. The level of implementation goes down to the municipality. So we have about where there is a partial county waiver. So for example, a portion of New York City has implemented the rule. The majority of New York City, 4 of the 5 boroughs, have not implemented it for the most part. Similarly, the city of Rochester and a couple of its surrounding suburbs are under a waiver, but the remainder of the surrounding county is subject to an ABAWD work rule. So it's a very, very complicated metric. And then sort of the third piece of it, I believe about, I think Andrew said 17, where they have fully implemented the rule. And in some cases, this is because of their labor numbers. And in a lot of cases, also, these are states where they have passed legislation at the state level that prevents them from seeking available waivers or taking available waivers if they were to be eligible for them. So it's an option, but it's not necessarily a requirement.
Well, thank you, Saima. So that really gets at the challenges of advocating for improvements on this. So when you're dealing with sort of this patchwork of situations. So I want to talk about the advocacy tools here. I'd like to focus on this. Now, based on Andrew and MacKenzie's article, I understand there are several different ways to advocate on this to make sure that the implementation is done as legally as could be, and to protect people from this time limit. I want to talk about a couple of ways to advocate on this, one being litigation, one being policy. And I know that Andrew and MacKenzie have been involved with a lot with sort of policy advocacy in Illinois, so I'm going to start with you and policy. And I even want to break this out into places that have implemented the time limit and have not. So MacKenzie, I'll start with you. Let's say you're in Illinois, which, as Saima mentioned, statewide has not brought back the time limit. What in situations like this where the time limit has not been implemented, what can advocates be doing policy-wise?
Yeah, so I think there are a couple of concrete suggestions we can make, but I also want to make a point about, I think Saima touched on this a little bit, but this is a really complicated rule to administer from the state's perspective, from a county's perspective, all the way down to a caseworker. So it really comes at the tail end, or not the tail end, I guess, but we're in a trend where we're moving towards simplified applications and redeterminations, and adding this level of detail to someone's eligibility screening is really goes against that trend. And so we see caseworkers struggling to deal with this when it is implemented, and we see states trying to figure out how to do something that they largely haven't had to do for a long time, but also goes against this general simplification trend and reliance on data, electronic data. So in general, it's a really tough and heavy lift for a state. So the things that we've seen other states do well are the things that we're focused here in Illinois on, knowing that we'll probably have at least some areas of the state have a time limit in December. So things like writing your policies, not just to reflect the federal legal language, which, as one of the only non-lawyers in the chat, or the only non-lawyer, I mean, I think it's incredibly difficult to interpret case by case what that would mean for an individual if you're sitting across from them and trying to figure out if this time limit applies. So trying to expand that language, talking to your state about how they can write a more clear policy and expansive policy, I think that's a great first step if you have some time. The other thing that we've seen states do, the states that have done well in this implementation or better have verification tools that are really simple. So a one-page form that you can give to any sort of medical provider or social worker to verify that this person has significant barriers to work, whether or not they meet the federal standard for an SSI determination or they're receiving disability benefit. So I think anything to kind of clarify what your policy is and how to verify that exemption is a really great place to start. And just to note, so based on the already existing schedule of how SNAP redeterminations are done, you probably within 6 months or a year of implementing a time limit, you should have this policy written and be applying it to the cases, because you really need that time to touch every case that this rule might apply to, which in the way, again, that states administer benefits, that's a really heavy lift to ask them to be prepared a year out or 6 months out to implement something this complicated. So as much as you can, raising this early, I mean, I assume many of people on the Hangout today actually have the time limit in their state, and some of these things can be done retroactively, but I really think clarifying policy, good tools for verification, and I know some advocates have actually created those outside of their state's official policy, but yeah, so there's a variety of things when it comes to policy advocacy, but really starting early would be good for a state that's anticipating a time limit.
Thank you, MacKenzie. And Andrew, I'll talk to you about areas where the time limit is already in place. What kind of policy advocacy should people be considering there?
Sure thing. Well, as MacKenzie referred to, you know, the state policy, you know, the state policy manual is not set in stone, right? So even if the state has implemented the time limit, there is still an advocacy strategy to change some of the policy. And for, you know, some states who've implemented the time limit, that experience might be their best teacher. Right, because they've tried to implement the time limit, they're trying to do those redeterminations, and they're coming up with error rates and a bunch of false positives, maybe false negatives. Some of that information is actually going to the federal government, going to FNS, the federal agency that Saima referred to that administers the or kind of regulates the food stamp program, the SNAP program that states administer. Right, so you actually might be able to work with them on some of those exemptions, and those exemptions to the time limit, like individuals who are medically certified as physically or mentally unfit for employment. That's a kind of different definition for disability than we see in other areas of public benefits law, like Social Security. And so there is some advocacy strategy, and I would urge people, even where they're in a state where they've implemented the time limit, partially in the state or statewide, to not give up on those exemptions. In terms of the other issues that we're not dealing with yet in Illinois because we haven't implemented the time limit, the tracking and the counting of months is actually can be quite complicated, right? So determining when people have hit those 3 months. And so working with the state for, you know, how they're going to make those determinations would be on my checklist. And another piece on my checklist would be, or item on my checklist would be from the federal regulations. You're actually allowed to exempt 15% of the ABAWD caseload from the time limit for an additional month. And this is something that states have done better or worse depending on the state. And I would kind of push the state to say, okay, how are you using that 15% exemption? Are you going to try and exempt homeless SNAP recipients or people in a certain geographic area in the state? And that's a really powerful tool in your toolkit. So I wouldn't give up on the 15% exemption either.
Thank you, Andrew. And I want to remind our viewers, we would love to hear your questions. And we're about to turn to litigation, which I know often people have a lot of questions about. You can submit the question through the live chat on YouTube or email me at Amanda Moore, MOORE, at povertylaw.org. So Saima, let's talk about litigation. What are some of the legal hooks that attorneys should explore if they're concerned about the SNAP time limit where they are?
I think there are several. You know, there are an extensive set of regulations and sub-regulatory letters around this. So there are claims that can be formulated around violations of the Food Stamp Act and the Food Stamp Program requirements. Those are essentially bolstered by claims about constitutional due process. There are procedural aspects that need to be followed and steps that should be taken as Andrew mentioned, it's extremely complicated to keep track of ABAWDs and to make sure that the state is doing what it needs to do to terminate people at the right time and also allow them to regain eligibility, which is something that is very, very difficult just to keep track of and to know sort of when people hit their triggers. So those raise issues around whether or not procedures are fair, whether or not people can access the system and they have enough information about what the rules are, what effect those rules have on them, how to meet the burden that they have. And then there are a whole range of issues with the sufficiency of the notice. The food stamp regulations offer a pretty nice set of guidelines about what is sufficient notice and what needs a termination notice, as many of us will call it. I think it's very common, just having had sort of incidental conversations with advocates from other states, to see states of adverse action that are not very good and don't necessarily meet all of the federal requirements. And that's unfortunately a common problem. And this is a very complicated rule. In order to give people sufficient information about the rule and what their rights are in regards to it, a notice has to be fairly well crafted. And then I think sort of the final aspect that I have thought a little bit about and that I think some other folks are thinking about but has not really been deeply fleshed out in the context of the ABAWD rule would be to look at whether or not there are systemic violations of the Americans with Disabilities Act, specifically around the fact that this rule is not meant to apply to people who are medically certified as mentally or physically unfit for work, and that's the wording that's in the federal statutes and regulations. And so to the extent that there are not avenues for people who would meet that criteria to fully explore it and to exercise the right to claim an exemption that they should be receiving, I think there are concerns that would be triggering ADA protections.
So Saima, tell us a little bit about your experience as you've been litigating this in New York.
Sure. I will start by saying it's not just me by any stretch of the imagination. This is a pretty big case, and there's an amazing litigation team working on it. It includes folks both from Empire Justice, where I work, and the National Center for Law and Economic Justice has been our partner in this every step of the way, and they've been really exceptional in that. We filed a case in August to challenge the ABAWD notices, the termination notices that were being used here in New York. The rule was re-implemented here. We had a partial waiver starting from the beginning of January 2016. So our ABAWDs became subject to work requirements at the beginning of last year, and then the terminations of ABAWDs started in April of 2016, and we filed the case in August. The claims in the case have very much to do with the sufficiency of the termination notices, the sort of lack of procedure that is being used for identifying people who are exempt or would be able to claim an exemption, the fact that people didn't receive sufficient notice of what the work, how to meet them, where to report the information, and how to regain eligibility. So a host of the things that we've already talked about in this. There has been some motion practice, so we filed motions for class certification and preliminary injunction. Moved to dismiss. And there was a lot of argument that on all of the motions combined in November. And we are unfortunately still waiting for our decision at this point. So it's been about 5 months now, but are continuing to keep our hopes up and think the best of these things.
Great. Well, we'll be sure to keep an ear and eye out for the decision when it does come.
Absolutely.
We had a question that came in before the broadcast from Barbara. She wanted us to basically speak to some of the differences in the ABAWD rule and in the rules around the employment and training program with SNAP, and how those affect people between the ages of 50 and 60. Andrew, can you speak to that?
Sure thing. So as we mentioned, right, the ABAWD time limit applies to people between the ages of 18 and 49. There's also a kind of distinct SNAP employment and training program, and people up to the age of 60 are actually eligible for that program. Now, it depends on whether a state has a mandatory employment and training program or a voluntary employment and training program. So in our state, we have a mandatory program in some parts of the state, but we also have policy that says people between the ages of 50 and 60, while they're eligible to participate in SNAP ENT, they're not required to. So I think that's the distinction between the ABAWD time limit and then the SNAP ENT age range and eligibility. But I think that goes to a broader issue, which adds yet another level of complexity to the SNAP ABAWD time limit, which is that SNAP state agencies administering SNAP are increasingly running that SNAP ENT program, and they're looking to use that program both to connect SNAP recipients to work, but unfortunately, in a kind of cynical sense, they're using it as a way to sanction people and kick people off the program. And so, you know, if you look at the complaint filed in Florida, in addition to bringing due process challenges to the ABAWD program, they're also challenging the way in which Florida is implementing the employment and training program and how they're kind of using them in conjunction. So I'd encourage attorneys who are kind of interested in that to read the Florida complaint, because in addition to the complaint Saima and her colleagues filed in New York, they give you a good sense of both the legal challenges and some of the factual matters that kind of underlie those complaints.
Right, and I'll encourage our viewers to check out Andrew and MacKenzie's article. It talks about the different cases that have been brought around the country on these time limit issues, one of which is in Florida, as Andrew mentioned. So there's a little more information about those in the article. We've heard in detail about New York today, but there are some others. Saima, I want to ask you a question that I feel like is just part of our daily life now. I need to ask about any of these issues at this point in time. Is there a chance that the waiver, you know, as a whole, the possibility of having a waiver from the time limit could just be done away with by the new administration?
That is a great question. So the waiver exists in federal statute. What the federal statute says is that the agency has discretion about it, which is kind of scary, I think, right now. But the second piece of the sort of waiver picture is that the federal regulations, which already exist and that have already been generated, set some more specific terms about the waivers. And what the federal regulations say right now is that the secretary will approve the waivers under the certain circumstances that are spelled out in the rest of that regulation. The sort of broad waivers that are sometimes approved, and I think the broader waivers that we certainly saw under the prior administration are not real likely to come forward in the immediate future. I do feel like the regulatory language that was promulgated to further the statute does not set a discretionary standard. I mean, the word in the regulation is will approve. The secretary will approve waivers when they're hitting that 10% unemployment threshold and when there's a designated labor surplus area, as we talked about before. So I feel like those protections are more strongly identified with those existing waiver criteria, and those would continue in place until the regulations are presumably revised, if that were to happen.
Thank you. We had a couple of questions come in, and I think both of them can have a quick answer because we are really at the end of our time, but I'd like to address these if we could before we go. One is from Susan, who had another question about the Florida case and wondered how to get a copy of the complaint in the Florida case. Do you all know? I can't remember if it's linked in the article or not.
I don't think it's linked in the article. We definitely refer to the Florida litigation. I've been carrying around a hard copy in my backpack for a couple of months. You know, it's a publicly filed document, so we can just figure out a way to make that available to anyone who would like an electronic copy, because we have one here at the Shriver Center.
Great. Okay. And I'm trying to remember, do we know what was NCLEJ involved with that one?
Yeah,
Yes.
NCLEJ is involved with it, and I believe Florida Legal. It's Cindy's program. I was going to say Cindy's case.
Yeah.
NCLEJ often posts things as well on their site. I'm not sure if that case is up there or not, but Susan, we can get that to you if you can't find it. Let us know. And we also had a question from Sakina that was asking about how to find solid data on ABAWD participation by state. Do you all know of a handy place to go for that data?
I have a couple of thoughts. So sometimes these numbers are conflicting because it depends on how states are thinking about even their case coding when it comes to these old systems or new systems, depending on if you're in a lucky state with a new system or not. But so you can go to the FNS has an annual characteristics report for all SNAP households, and that will give you one estimate of the number of childless adults in your state. The other thing is that it should be publicly available, but some states don't post them, but your state's employment and training plan, you have to report the number of people who are mandatory in your state, the number of people who are subject to the time limit. So this acronym ABAWD is used in that report as well. So just look for that number. But we've seen different numbers even within our own state, but those are two places to look. And then always, I think asking your state agency is a good way to kind of start this conversation about just how many people could be impacted by a poorly planned and executed implementation. I would just say in Florida, for example, over 400,000 people are part of this class of folks who has lost SNAP because of this. So while it's a small part of the overall caseload, it is a significant one. And so this is why so many people have been thinking about, talking about, and planning around this time limit across the country.
Well, I will add, there was more to the question we don't have time to get into, but Sakina had mentioned that Louisiana's information was hard to find and has not had extensive success getting it from a public information officer there. So, but I will say that when we send out this follow-up email, either later this week or early next week, we can include some of these links that MacKenzie mentioned to people, so you'll kind of have those at the ready of places to find this data, or these data, and then also if we can figure out the Florida complaint, we'll get that included as well. Well, I want to thank everyone for watching today, and I want to thank my three guests for joining me. It's been a great conversation. I also want to remind everyone that you can read MacKenzie and Andrew's article, SNAP's Time Limit, Emerging Issues in Litigation and Implementation. You can find that at povertylaw.org/clearinghouse. And as we've mentioned, there are more citations and more details in the article. If you found today's conversation interesting, please join our mailing list. You'll be kept up to date then on future articles and future events. You can find that at connect.povertylaw.org/clearinghouse. And also remind you that the Shriver Center offers multi-day online and in-person training courses. The next one that we have coming up is in May, and it's our online Supervising for Quality and Impact course. It's a one-of-a-kind experience. You can learn and hone your supervision style to build a stronger and more effective organization. You can find out more about that at povertylaw.org/clearinghouse/training. And finally, I want to invite you to join us for next month's Advocacy Exchange. We'll be discussing criminal justice debt and how attorneys around the country, including those in LSC-funded programs, are working to curb the fines and fees that disproportionately harm people in poverty. I'll be joined by Rona Taylor and Nick Allen from Columbia Legal Services in Seattle. Keep an eye on your inbox for more details and a link to register for that. So we hope you will join us next month for that. And until then, remember that you are not alone out there. Thank you.